When a client calls you the day or week they receive a demand letter, what are the first two things you tell them to do, and maybe what are the first two things you tell them not to do?
We're always interested in understanding the client's business and potential legal defenses. So, of course, Jake, there's still some debate in the courts about what exactly is a public accommodation. What does the ADA apply to? Do you have to have a brick and mortar location, or can you be a pure online business? And that question remains unresolved at a national level. So, understanding the client's business and seeing if there are legal arguments we can make about that, or potentially about personal jurisdiction, whether they're being sued in the right place, whether their website is really commercial in nature or is less commercial, perhaps more brochure style, more informative. So the first thing I think we do is we try to investigate what the client's features are. I don't have too much concern about clients trying to figure out how to get their accessibility increased, even while a lawsuit is pending, for two reasons. First of all, if they choose a settlement strategy, if they want to pursue settlement, we're likely to agree with the plaintiff's lawyers that will perform some increased accessibility work. That's one reason. And the second reason is the ADA is a remedial statute. So defendants always have the ability to moot claims. I think about things in the physical world. If you're sued because there are two stairs up to the entrance to your building and you build a ramp that's compliant with the architectural guidelines for the ADA, you can moot the claim. And the same is true for website accessibility. If you are sued because you have a few shortcomings in your website accessibility, one of your potential avenues to respond is to remediate those claims. So I rarely tell clients to do nothing. I tell them that they should investigate whether they have legal defenses and determine whether they are comfortable with their current accessibility. Ultimately, almost every company I represent, or all of them, want to be accessible. That's really never an issue. It's a question of whether they feel like they've been unfairly targeted or caught in some highly technical failure that really isn't preventing disabled users from using their website. That's really where the action lies in these kind of claims.
Okay. So it's almost a combination of kind of looking inward to understand, if we're the type of business that should be under scrutiny is one piece, and then the other one is, how accessible as a brand and as an organization do we want to be for our customers? Kind of like answering those two questions.
That's exactly right. We've got to look at the law and the facts, and we also would need to make our response something that's going to meet the case, right? The legal claims, whether that's to defend it or to settle it. But also, as you said, these clients have their own ideas of what they want to do to make their business as customer friendly as it can be. And so we obviously want to work toward their goals.